Thank you very much, Presiding Officer. Colleagues will remember that the Coronavirus Recovery and Reform Scotland Act 2022 included a number of temporary justice measures to make sure that our justice system was able to respond to the acute impact of the pandemic. While there has been significant progress towards recovery, we still have some way to go. Therefore, it is necessary to extend the remaining measures for one final year so that they stay in effect until the end of 30th of November 2025. And this move has been backed by our justice partners. There has been considerable progress in reducing the backlog of cases in the courts, with outstanding scheduled trials falling by over 45% between January 2022 and September 2024. However, modelling by the Scottish Courts and Tribunal Service anticipates that backlogs and solemn trials will continue above the target baseline until 2026-27. Therefore, these measures will ensure court resources are used efficiently. The availability of the higher maximum fiscal fine means that, where appropriate, more summary cases can be diverted from prosecution, reducing the number of cases that go to court. We are talking about cases that would normally, potentially, if they were not subject to a fiscal fine, would go to the Justice of the Peace Court and in all likelihood be subject to a financial penalty. So there is a pragmatic reason for the use of fiscal fines. And I also, following my evidence session to committee recently, Presiding Officer, followed up in correspondence with committee on the 24th of October, outlining further information and presented particular data to the committee. Parliament might want to be aware that the Crown Office also regularly updates Parliament on a range of matters relating to its functions. Turning to the two extended time limits, these are for one further year only. There is no power to extend these beyond next year, and we are not introducing primary legislation to extend them either. These regulations are necessary to increase the court's capacity to hear trials by, again, ensuring that the resources are not diverted to holding large numbers of procedural hearings to extend time limits on an individual case-by-case basis. And I'm sure Parliament does not want to risk compromising the court's capacity to focus on progressing trials and reducing the backlog. As the Lord Advocate highlighted to members on the 10th of October, removal of the time limits right now would present a serious risk that victims and witnesses may be deprived of their access to justice. Presiding Officer, to conclude, just to say that I acknowledge Mr Kerr's comments. There are indeed a limited number of these temporary measures that are being baked into permanent legislation that has been introduced to Parliament. And I believe that these regulations are a package and they are crucial to assisting the continued recovery with Parliament, and I propose the SSI to Parliament.